Hello everyone, welcome to ATN. I'm your host, Admin Dillon. And on September 1st, 2010, changes were made to the legislation affecting the Insurance Act, which affected compensation for personal injury claims. So to clarify these changes and to give us more information, I've got in the studio today, Nainesh Kotak from Kotak Law.
How are you?
I'm good, how are you?
Thank you for having me.
We love having people here that can give us information because you know what? It's interesting, this change was made, but a lot of people probably aren't aware of these changes or even what the previous legislation was. So for our viewers watching, we're going to clarify it. So right off the top, let's clarify. What was the legislation and then what were the changes that were made?
Right. So let me just give you a bit of a backdrop into the compensation scheme for people injured in accidents, and then I'll take you to these changes. So we have a two-tier system. Since the early 1990s, it became that way. So we have a no-fault system where one claims from their own insurer basic accident benefits. And this could include things like income replacement benefits, treatment, and it used to be housekeeping and attendant care and caregiving. There's also a fault portion where you claim against the party at fault who caused the loss. And that is done to litigation or a lawsuit. So up until September of 2010, I mean, there were some changes in the past, but I'll take you to just before then. There were more benefits, I would suggest, that people could access. For example, you could claim housekeeping benefits, there was caregiving benefits, in addition to income replacement benefits, and medical rehabilitation benefits up to $100,000, and if the injuries are catastrophic, you get a lot more.
I was going to say, let's say you lost a limb. Would you get compensation for that?
Yes. Under the old legislation, for catastrophic claims, you'd have to lose really two limbs. And I hate when we're looking at it in a way that way, but unfortunately that was the definition. Unless it caused tremendous psychological damage, when one could argue you have a catastrophic injury and you'll get more compensation for that. And I don't want to complicate it too much, but catastrophic injuries are sort of really another topic where there is a lot more compensation. But most injuries don't fall within that realm. Okay. So let's say you've had a shoulder injury, a back injury, but no fractures. So before September 2010, if you missed work, you can get from your own insurance, you'll get 80% of your net loss of income, up to $400 a week, unless you bought optional benefits to increase that number. There'd be housekeeping benefits available too. So, and it could be a spouse. It could have been a relative where you wouldn't even have to show the incurred expense, just the promise to pay, up to $100 a week. There were caregiving expenses, which really were useful for, I would say, stay-home moms, for example, where they're not working. It gave them a benefit. They needed help looking after their kids, and they would have that benefit. What these changes did in September of 2010 is they took away a lot of those rights, took away much of what could be claimed under the no-fault system. The fault system essentially remained the same as it had been since 2003, but the no-fault, and I think was quite, what I would suggest, decimated. If you want, I can give you some examples.
Yes, please.
Okay. First of all, housekeeping has been taken out. No housekeeping claims unless you have catastrophic injuries or unless you paid more premium to buy an optional benefit. Same for caregiving expenses. Income replacement benefits are paid at 70% of the gross, up to $400 a week, which is similar to the 80% of a net, so that wasn't affected too much. Where I think accident victims have been, I'm going to be very politically correct here, but I would say harmed, is with medical rehabilitation as well. Because the limit before was $100,000 for non-catastrophic injuries, and that would cover such things as chiropractic treatment, physiotherapy, certain medical devices. It got reduced to $50,000. But hidden in the legislation, and I think it was snuck in almost as really an afterthought, limited medical rehabilitation benefits to $3,500 if the injury is considered to fall within the minor injury guideline, which majority of injuries unfortunately do. Now, there's been some case law recently that has sort of challenged that, and the courts have held that where there's chronic pain, where there's psychological trauma, that prima facie takes you out of the minor injury guideline, and the insurance company has to show why you should still be within it. But a lot of people don't realize that, and many people get discouraged when they're told by their insurer, we're not approving your treatment, this is all you get. and people aren't getting better, and it's causing, and we see it frontline, I'm a litigation lawyer who deals with this all the time, and we see the effects on people when they're not getting treated how they used to be.
So why would these changes even be made then?
Okay. There's always this balancing between really two, I would say, political forces. One is trying to keep the premiums stabilized. Okay, so it often is a big election issue. When premiums go up, the public gets upset and they blame the government at hand. And also insurance companies, let's face it, they're in the business of making money. They have shareholders to answer to, so they want to make more profits. Well, how do you make more profits? You can make the right investments, but you can also try to limit how much money you pay out on a claim. So that's one factor, one lobbying force is the insurance industry to reduce the amount of payout, so they have theoretically greater profit. With that, the government looks at it, well, if insurance companies then, they won't threaten to raise premiums because they're not spending so much money out. At the end of the day, in this political battle, who suffers? It's the accident victim.
Exactly.
And really, these changes have been in since September of 2010. We're talking 3 years of dramatically reduced payouts on claims for accident benefits. The fault portion is still relatively the same. But have we really seen premiums go down? I mean, I haven't. I don't think we've seen that much of it. I think either up or the same.
So is there any opportunity for lobbyists or anyone else to go back to the government and say, it's been 3 years, it hasn't really improved anything, so why not maybe make further changes and maybe bring it back to where it was?
There is a statutory review always that occurs periodically. But, you find it's almost like taxes. Once a tax is imposed, HST, for example, despite lobbying against it, once it's there, once money is being made, very hard to take it away. And similarly, once cutbacks have been made for what insurance the industry will have to pay out to victims of injuries, very hard to put that back in. Once it's almost like once the genie's out of the bottle, you can't put that genie back in.
Okay. Yeah. Well, we're going to definitely get more information from you because it's a very interesting topic, but we can take a little break. So, folks, don't go anywhere. We'll be right back. Welcome back to ATN. I'm your host, Damon Dillon. Still chatting with Nainesh Kotak from Kotak Law. Well, you know what? You've done a really great job of clarifying all this, legal talk almost of a legislation and the changes to the Insurance Act. But let's clarify a little bit about at-fault legislation, or I guess claims I should talk about. Once again, maybe just recap the difference between the two, and then how do you establish that type of claim?
Okay. And again, I'll just reiterate, there's two schemes of compensation if someone is injured in a car accident. The first are no-fault benefits. They're regulated by statute. Income replacement benefits, a certain amount of therapy. There's another benefit called non-earner as well. And they're available regardless of who's at fault in the accident. Now, if you are a victim of an accident and it's been caused by the fault of another, you can sue. You can sue for pain and suffering. You can sue for future health care, for income loss.
Does it have to be 100% their fault, or can there be like a percentage?
A good point. For example, let's say it's a 50-50 responsibility. It could be the witnesses are back and forth. It's hard to tell who ran the red light, for example, or somebody made a left on a yellow when the person went through that yellow. There could be a portioning of responsibility. Let's say, for example, someone's injuries are worth, hypothetically, $50,000. But if they're found to be half at fault, those damages get reduced by half, down to $25,000. So you don't have to be completely not at fault to make the claim. Now, what's important is this. In an effort to keep premiums low, and that was a theory behind this, in the 1990s, a deductible was put in place for awards for pain and suffering. Right now, and in 2003, it was increased to $30,000. That's the deductible. Now, if you go to a trial, the jury, when they award money, they don't know about this deductible. So if they award $40,000, they don't realize $30,000 is kept by the insurance company for the party at fault. The person who was awarded damages doesn't get it. Okay, so that's one area that I would say a lot of advocates for victims of injuries have real issues with. Is that, okay, we have this no-fault system, and then we have this deductible put in. And not only is there a deductible, but to get any money for pain and suffering, the person's injuries have to be serious and permanent. And the legal jargon is you suffer from a serious and permanent impairment of an important bodily, mental, or psychological function, or you've suffered death or permanent and serious disfigurement. So if the pain and suffering is, I should say, is above $100,000, there's no deductible. But to get above $100,000, you need quite significant injuries. So already there's this threshold to meet for pain and suffering. And even if you meet it, a good chance if you won't be over 100, you lose the $30,000. It doesn't mean there aren't awards, and sometimes significant awards for pain and suffering and future income loss. And that's really the job of the advocate, to build that case with the medical practitioners to prove that there is a loss that needs to be well compensated.
I'm going to ask you for your opinion on this. It just sounds like it's getting harder and harder for these types of claims to go through and then for them to get any sort of compensation. Do you agree with that, or is it just sounds like it?
No, I absolutely agree with it. It's an uphill battle. You know,
all these loopholes.
Well, I'll tell you something. You know, the Insurance Act, in my opinion, I think it's as complicated as the Income Tax Act. Now, Income Tax Act I studied in law school, and it is obviously very confusing, but so is the Insurance Act. And for someone to, if you're injured, and to try to represent yourself and think you're going to be fairly compensated at the end of the day, I think that's a dream, because the legislation is complicated. There's different interests at stake. Insurers, at the end of the day, like I said, look, they do try to be fair, but the bottom line is they answer to their shareholders. They want to save money, not spend it on claims if they don't have to. And in my opinion, if someone is hurt in an accident, you need a lawyer. I'm
from Manitoba, so I'm used to a very public type of system.
Yes.
So here, it's I'm not very familiar with it, and so I'm just wondering, how does Ontario compare to the other provinces in terms of insurance?
Let me compare it to the pure no-fault systems. We have that, as you're from Manitoba, we have that there and in Quebec as well. I think the system we have is much better for people who have been in accidents, and I'll tell you why. Under a pure no-fault system, there is no right to sue. And it's an administrative process where really you don't have an advocate on your behalf. The decisions are made pretty swiftly, and injuries are pegged in certain amounts without really looking at the individual circumstances of the person. So comparing us to, for example, Quebec and Manitoba, I think we are much better off. Now, people would argue, well, do they not pay less premiums than us? Well, I think we have more drivers. We probably have more accidents than they do, and that would affect premiums.
But I'm just wondering if maybe the insurance benefits are better because of that, right?
You know, for the no-fault benefits, the statutory benefits, they're more geared to that, so that may well be the case. And I don't know the full specifics because I practice in Ontario, but you may be right there. But eliminating the tort claim, the litigation claim, where really that's where the majority of the compensation is. To eliminate that severely, I think, impairs a victim's ability to be fully compensated for their injuries.
So I can only imagine how confusing it gets, because I'm just thinking of my experience in Manitoba, and I know of several people that worked in insurance there, and so, you know, it always just sounded very straightforward of, okay, if there's a claim, if it's a good claim, there's so much that they will get, right? And usually, you know, they were covered for, from what I understand, throughout their claims. Like, especially in school, we would look at work injuries, right? And I always would, when we would interview subjects, they'd always talk about how they could get benefits as long as they needed. So it's a very interesting topic, and I can definitely see why people would get the debate going. We got to take a little break. We're going to have lots more coming up from you. But folks, we'll be right back. Don't go anywhere. Welcome back to ATN, folks. I'm your host, Sam Dillon. Still chatting with Nainesh Kotak from Kotak Law. So we're almost out of time, but it's such an interesting topic. So, I mean, we could have so many shows on this. Let's talk about now how your firm, Kotak Law, how do you help clients that have these claims and they want to come and get some help from you?
Thank you. Well, we're a boutique personal injury law firm, 2 lawyers and quite a few law clerks and support staff. So we pay what I would say is very individual attention to each case. We don't get paid up front. We get paid at the end. So even if, sometimes people think, well, I don't have money. You don't have to have money. Hopefully, if we take your case, we will get you money.
So let's clarify that, because I
Yes.
know sometimes people are living paycheck to paycheck, and then they're injured and they're just stressed out. They're thinking, what am I going to do? So they don't even think they can get a lawyer. So if you get paid at the end, so let's say the claim doesn't go their way,
Right.
it gets denied, they don't get anything. What happens then?
Okay. I can say this: we don't take cases unless we feel very strong
Good,
about
okay.
it. Okay. And I think the cases are very few and far between where we don't get something for the client. So we rarely run into a situation where there is no money, because we screen initially, and the initial meetings are free. There's no cost for the initial meetings as well. So we help people who've been injured in car accidents with their no-fault claim and their litigation. We help people who have been denied benefits, other benefits from insurance companies. For example, many workers carry long-term disability insurance or short-term disability insurance through their work. Often you have denials, and our approach on that is quite aggressive. We litigate those claims until the end. We push for the most for our clients. Slip and fall cases, and people should be careful, wear boots and all that. But sometimes it's inevitable. Somebody falls, there's a spill, the ground has not been salted. So we assist people who have been injured in slip and fall or trip and fall claims as well. Sometimes people have applied for Canada Pension Plan disability and been denied. We help people with those claims as well. So it's not just car accidents. We're very personal, we're easy to get along with. The initial interview is with myself, and a law clerk will come in as well. And these cases take time to settle. The typical car accident case, the no-fault case, takes, I would say, 1 to 2 years to settle.
Wow.
And the fault case, 2 to 4 years to settle.
So what does somebody do in the meanwhile while they're waiting?
Hopefully they're getting benefits in the meantime. And sometimes what happens is that people do go back to work, and that's great. If you should always get medical advice and try to work if you can. But maybe they don't work to the full capacity, and we try to get that difference in income for them. So, the hope is that they're not going to be sitting back with zero money for 4 years. That doesn't usually happen. They tap into the benefits that are available.
I want to ask because, I know a lot of our viewers, a lot of them are newcomers when they're coming to Canada, so they're not familiar with the system, so fantastic. I'm sure from the first assessment, they'll get some information from you.
Yes.
But, they probably are in kind of starter jobs, not a lot of income, maybe don't have family here support, have a mortgage, have all these things, sponsorship costs. Unfortunately, if they have an injury, I'm just trying to put myself in their shoes. So those type of clients that you see coming in, maybe you just talk to us a little bit about the scenario and what kind of other maybe resources you help them tap into when they've got all these costs, and if it's taking 1 to 2 years for a claim to settle, what do they do in the meanwhile?
Okay. It's a very interesting example you've given. You could have somebody who's just come to Canada, maybe they've been working for a year, maybe even less. So they can't access a lot of the social programs that maybe we have. They can't access Canada Pension Plan. They haven't contributed. And even with their no-fault claim, under their own insurance, or if they don't have their own insurance, they'd go under who they're dependent upon, or they have a driver's insurance, even for the no-fault claim as well. But their benefit they're getting for income replacement benefits may not be reflective of their true potential. They may have had a great career ahead of them, but were working at a job with less pay to get by before they progressed. So the effect of that is this: under the no-fault claim, they're stuck with 70% of the gross loss of income, whatever it was. But on the fault claim, we argue that, look, the income loss calculation must be based on their potential in their situation, and not on their past earnings, because they were newcomers. And we've been very successful with that argument. But you're right, it is a bit of a struggle until that case is settled with the other driver's insurance. Initially, they'll be getting pay from their own insurance, but it won't be truly reflective of their income potential.
What if they don't have insurance? What if it's slip and fall?
Okay.
Right?
And correct, because we have a pure fault system for slip and fall. So in those situations, somebody falls down, and if they have fractures and no income coming in, first look to the employer. Do they have short-term disability or long-term disability, and apply under it? If that's not available, it is a very difficult situation for people. Because, in those situations, we try to advance the litigation as fast as possible. We try to ask for an advance payment to help them out. And really, unfortunately, the last resort is some sort of social assistance, which is very unfortunate because a lot of newcomers don't want to go that route.
Yeah.
But that
Or they don't qualify, like you were saying.
yes, there's some benefits they may not qualify, or some they may, and that really is the last resort. The key then is getting good rehabilitation in play to try to get them back to work or a state where they can at least earn some income.
So, you know, I always think, especially in the movies and in media, sometimes it just seems scary to think about, you know, quote unquote, suing someone to, you know, if you're injured. You know, they make it seem very ugly, right? So maybe just to show us a little bit of realistic view here, the types of claims you're coming in and seeing, maybe just overall, you know, yes, it's a year to two to settle, but you were saying most of the time you do get something for them, right? It's not this, you know, ugly battle where, you know, their character is coming in and, you know, someone's trying to say that they're lying. You know, maybe explain to us a little bit about how the system is and establishing proof and, you know, maybe even on the average what people are getting. So people that are considering, you know, coming, but they're just thinking, what's the point? I'm gonna, you know, not qualify, or it's just gonna be a waste of time. Maybe clarify for them.
I mean, there always is apprehension on the part of people to be involved in the court process, to make claims. But keep in mind that if somebody is injured, truly injured, they're not being a burden on the lawyer by coming to them. They're not being a burden on the system by making an application for benefits they're entitled to, because that is the purpose of having lawyers. That's the purpose of having these benefits in the first place. So people should not hesitate, first of all. What we do is we take a full interview, and we really try to say, okay, where can this person, where should they be compensated? Where can they be compensated? We speak to their doctors if we have to, and we make the appropriate realistic claims that have to be made. If it's a car accident with a no-fault insurer, with the other driver, if there's other policies at play, long-term disability policies, we encourage that, have them apply, and if they're denied, we take that to litigation as well. It's not a criminal process. It's not like somebody's being accused of doing wrong. They're the ones who have been wronged. Okay, so you know that shouldn't be a worry. The stigma of being involved in a lawsuit, you have to keep in mind that even though the person you're suing is an individual, the lawyers are hired by their insurance company to defend them. Their insurance company is the one who pays out at the end of the day, and that's why we have insurance. You know, there are cases, for example, where you have spouses suing spouses. Let's say the couple are driving, the person driving dozes off, he or she dozes off and crashes, and the passenger is injured. Well, they have to sue their spouse. But what's the effect of that? The premium may go up, but it would go up anyway because of the at-fault accident. So it is not as personal as other types of litigation, such as family law litigation or contract litigation between business partners. It's not like that. So we really like to demystify that, so to speak, and have people, you know, if you're injured and you have a legitimate claim, by all means go for it. Because if you don't take that step, you're going to lose out on what's fair to you.
Exactly, and at least come in for the initial assessment. So
Exactly.
for our viewers that do want to get in touch, let us know how they can.
Absolutely. Well, our website, kotaklaw.com, email info@kotaklaw.com, and our local number, 905-755-8900. And we're out there, happy to help.
Well, thank you so much for clarifying. Like I said, it's a big debate, a lot of interesting facts there. So thank you so much. And folks, feel free to get in touch and definitely get some more information for yourself. Thank you so much for tuning in. You've been watching ATN. I'm your host, Amin Dillon, signing off for today's episode.